Oh, thank you very much. Thank you, Dr. Collins. Thank you very much. We're very excited to be here with you and talk about this study. This was the first study that, how do I do this, Pete? Get me on here. This was the first study of its kind in the country that had capital qualified counsel with social scientists working together on this kind of study. And we were able to get an awful lot of great data, which Pete's going to talk about. And it's really the first comprehensive empirical study of its kind in Washington. Mark had done some really significant work earlier, but this one had a lot more data available to it. The whole idea of this study was to figure out whether and what the differences are between cases in which the death penalty is sought and cases in which the death penalty was not sought, all aggravated homicide cases in Washington. And Pete will tell us about the details.
Hi there. Thanks for having me and welcome all. I'm going to start by just talking a little bit about some previous studies and then a little bit about my experience in other states as well as in Washington, and then we'll go through some of the particulars of the Washington State study, and then we'll hand it back and forth for some other information for you. What I wanted to begin with was that after, or really during the process of the Washington study, we, as a group, were looking at other research that had been conducted, and since then I have been collecting studies and looking at findings to help not only guide the research that we've been engaged in and have continued to be engaged in, and but also just to see what the trends are in other states and other jurisdictions. And we ended up with a list of about 28 studies from 1982. The bulk of those studies have been completed at the turn of the century in the last 15 to 20 years, and really post the recession in 2007, as we all know, issues with budgets and financial pressure have caused folks to look at things from a different perspective, maybe. But really, the take-home from all of this is that out of all of those studies, not one has shown that seeking the death penalty is cheaper than not. So it's a simple fact. Seeking the death penalty is more expensive, and we're going to talk about why that's the case here in a little bit. Here's a table for those of you watching online, and for those of you who might take a look at it later.
I have a quiz on this.
Yeah. Here's 15 studies that were conducted in several different states, and you can see that in 2017 dollars on that far right column. I apologize, there's a lot of information on this slide, but you can see how much there's variation, I guess, in the findings, but that they're all positive, meaning they're all more expensive. And the Washington, Oregon, Nebraska, and Oklahoma studies. The Oklahoma study hasn't been published yet, but that'll be soon. Have been the most recent. So, in talking a little bit about the experience that I've had doing some of these studies, I can say that the costs really are dependent upon the overall investment in the criminal justice system. And for example, especially with public defense, if the public defense system has support and funding, that will pan out in the data, and that data really matter. And expanding a little bit on that, on the data side, because that's kind of what I'm responsible for. I've found good data and bad data, but really both tell an interesting story. For the good data, we're looking at information that's tied to modern information management systems, and you can really see a reflection of quality practices, increased transparency, accountability, coordination, And examples here would be public defenders keeping track of their time on cases at the case level and their effort and costs, even some district attorneys doing the same thing, even though the system's set up differently for them. But I think there's been some realization from some offices that doing that allows them to maybe argue for more funding or expansion in their offices as well. And really looking at effort at the per case level. For the bad data, we're looking at outdated information management systems. Anybody that works in this system knows that most of these institutions and organizations are pretty far behind the curve. It's not for the fault of the people working in these systems. It's just because there's no funding for expanding those types of or adopting those types of technologies and things. But along with that, though, we have some issues with decreased transparency, accountability, and coordination among those organizations. An example would be the opposite of what I said before, but that would be public defenders not keeping track of their time at the per case level and district attorneys not doing the same. Agency to agency variable ability varies, obviously, but whole systems can really be defined as poor, average, or above average, I think, and that might be useful, to understand moving forward. Now, for the Washington cost study, as Bob alluded to earlier, we got together and took a look at previous studies and used that as a guide to really how we were going to go about doing our study. And so we took a look at all aggravated murder cases that resulted in a trial report or were adjudicated from 1981 to 2014. And that was an N, or population, of 339 cases. So only 339 from, for over 30 years. Washington's violent crime rate is much lower than the national average. That's a good thing. But methodologically that presents some issues, I think, especially with type 2 error or not being able to tease out some of the patterns. But that's what we were dealing with, and our two main concerns really from the beginning were looking at how to identify all the eligible cases and really to map out the chronology of a typical capital case, and that's where, as Bob stated earlier, having a team of death-qualified attorneys working with social scientists was really extremely helpful for us. For being a data person, I'm not a lawyer, so I didn't know exactly what all the intricate pieces of the process were. And I had these two guys helping out with that, and then we just went through and looked at what data were available. Once the cases were identified, we then made an effort to seek out data. And we requested using data using a variety of techniques. We looked at existing records. Mark had put together a database of all the trial reports that had taken place, I think, as an effort just on his own, and then as part of earlier research efforts. And that was, for me, extremely useful, for us, extremely useful, and that we had a good, solid base to start. And then through FOIA requests, we asked for budget documents for defenders, from the Defender Association, from State Defense Office, and from all other significant institutions and organizations. We also were lucky in the state of Washington to have access to Extraordinary Criminal Justice Act petitions. And if you're not familiar with those, that was maybe Mark or Bob can explain some of those things later, but you want to pause and explain what that is?
Well, we can do it very quickly.
Sure, I can explain that fairly quickly. Where the money is spent, meaning where the cost is fixated on, depends on whether it's at the trial or on appeal. If it's at the trial level, it would be from the county in which the trial would take place or where the charge has been initiated. If it's at the appellate level, whether it's on direct appeal and post-conviction, which we'll talk about a little bit later, it's funded by the state. And so the Extraordinary Criminal Justice Act was adopted in 1999 to allow for counties to seek reimbursement for cases that were extraordinary. Many of them are aggravated murder cases, but it's not necessarily limited to aggravated murder cases. But if a county's criminal budget is being absorbed by a large case in this study, aggravated murder cases, they can seek reimbursement through the Extraordinary Criminal Justice Act by the state.
So these petitions that we were looking at were the county telling the state how much money we spent on this case. So that was very useful to Pete in gathering the data and also checking against other sources. It allowed for double checking.
And I apologize. And just so it's clear, the amount that's submitted under the Extraordinary Criminal Justice Act goes beyond just the defense cost. It includes prosecution costs. It includes the defense costs. It may include experts. It includes court costs. It's anything as probably as because of the name, you can figure it out. Anything related to the criminal justice process. So it's not limited to just the defense or the prosecution.
Right.
And that was massively helpful to us because that was the counties organizing their receipts and things for costs that we could then, as Bob said, kind of triangulate with the requests that we'd made. And a lot of the documents were similar that we got through the FOIA requests that were in the Extraordinary Criminal Justice Act petitions. And so that just gave us some internal validity to the measures that we were collecting, or the data we were collecting. And we also asked through existing open channels, the relationships that we all had with various people in various organizations, asking for data. Our analysis contains 6 main categories, but it's without reading the entire report, you should just know that those categories are aggregate and they can contain a lot of other subcategories. But those included jail costs, defense costs, prosecutor costs, court, police, sheriff, miscellaneous costs, and appeals at state level. Example there for defense costs would be salaries, expert witness costs, and investigation costs for each case. I'll just go through a few of our findings. At the end, we discovered that aggravated murder cases where prosecutors decide to seek the death penalty costs an average between $800 and $1 million per case, compared to similar and for the lower number matched propensity score match cases, but similar non-SAW aggravated murder cases. These findings were in line with previous state-level studies, especially the more academic or empirical studies done by, for example, the Maryland study by Roman and the North Carolina study done by Cook. So we were, right in line with those. And recent data also indicated that recent cases were significantly higher than previous cases, and those were continuing to grow. So pursuit of the death penalty in Washington has become, along with that, less probable over the last 40 years. If you just wanted to put in a cite for the WSBA study, that I think that's the previous study that you guys did, right? Or the one before there was some county maps,
right,
and some development over time of the shrinking of where those cases were taking place. I would say take a look at that. It's pretty interesting. Here we have some from the trial reports, the percent of the cases where the death penalty was sought by decade, and I think the next slide's probably better to see that trend, beginning with 39% of the aggravated murder cases being sought in the 80s, down to 5.26 in the current decade, and this was at the time of the study, and I'm not sure. That represented, I think, 1 out of 19 cases, and I'm not sure if that's increased to 2 or 3 since we completed the study, but possibly. But it's still much smaller of a proportion of the cases. And so, last for this bit of the talk, the the idea of these cases becoming more expensive is a good example would be the last 3 King County cases, which had been ongoing at the time that we were conducting the study. They weren't completed yet, and a couple of them hadn't even gone to trial. But as you know, those had cost well over $15 million combined, and did not result in the death penalty. And I save this maybe for the last point too. Mark's going to talk about this as well, but really it's an exercise in futility when you see the reversal rate post conviction. 75% have completed their review, have been resulted in reversal, compared to 7.5 of the cases that were not death sought, resulting in reversal on appeal. So I'll turn it on back over to Bob.
I wanted to talk a little bit about why these cases are more expensive, and for people that are not familiar with capital litigation, we want to go through some of the reasons. In Washington, we have a court rule. It's called the Special Proceedings Rule, and it sets out requirements for the lawyers that are going to be doing the defense work. They have to be, in the term of art, learned in the law of capital punishment, and then they have to have special training and experience, and they have to have minimum levels of experience. So that's different than, it's a little bit more advanced than if the death penalty is not involved. And they have to go through an application process and certification process, and then periodically have to show that they're still learned in the law. They have gone to training, and they have continued to pursue education so that they're capable of handling the complexity of the work. The appellate courts have made it really clear that comprehensive work is required. Both the United States Supreme Court and the Washington Supreme Court have reversed death penalty cases because the lawyers haven't done enough work on the case. And so, for example, this is more than one time that the court has reversed death penalty verdicts because the lawyers did not fully investigate the mental health of their client. In one case, the lawyers didn't even look in the court file that was available, and the U.S. Supreme Court said they should have done that. Also, the cases can take a very long time, much longer. As Pete was saying, the 3 King County cases went on for years and ended up without a death penalty verdict. This example that I've put in this slide here, the Stenson case, in this one the court reversed both the conviction and the death penalty because the prosecutor did not disclose evidence that could have helped the defense. And prior to that decision, the Supreme Court had denied his direct appeal and 4 personal restraint petitions, which are post-conviction claims after the appeal is over or simultaneous with the appeal. Mark will talk more about that. So to me, this is an example of how complicated and how long these cases can be, that eventually the court decided, yes, there was a big problem, big enough that we're going to reverse the whole case, and it took them 6 times before they did that. So these cases are fundamentally different than so-called regular homicide cases. They're more detailed, usually in the kinds of information that the defense is processing through. They're legally more complex. There's all kinds of issues, motion practice that the lawyers have to engage in, and the procedures are more complicated, in great part because there's 2 parts of the trial. There's the guilt phase, and then there's the sentencing phase, both of which have juries. The American Bar Association has given a kind of summary comment about this, about issues that are unique to capital cases, and these include special voir dire, special jury selection questions and processes, the fact that there's 2 types of or 2 parts of the trial, the guilt and the penalty phases, and that the jury has to make special findings. In Washington, we have statutory requirements about that. And the State Bar Association standards talk about what is supposed to happen in a capital case. Mark was very much involved in this in this work, and recommending that the defense team have, at a minimum, 2 attorneys, a mitigation specialist, someone who's going to help both to persuade, ideally, the prosecutor not to seek the death penalty, but if it does go to trial, to persuade the jury that the death penalty is not appropriate, an investigator to look into the facts of the case, and then whatever mental health experts are required. And this is now required by court rule. And to give you a sense of how critical it is that the staffing be complete, here in King County we developed a practice, which is still in place, that if there is a capital case or a possible capital case, the county will fund 2 full-time lawyers and an investigator for the pendency of that case, which could go on for years. So you have 2 full-time lawyers and an investigator working on really nothing else. Now, the way the defenders often do it is they have pieces of several people so that it's not just 2 people, but it's 2 full-time equivalent people. The motion practice, the kinds of issues that lawyers have to raise either before or during trial become much more complex as well, and it's critical that the lawyers raise every possible issue that could be raised so that they're preserving their issues both for state appeal and federal review later on. In part because of the jury selection taking longer and because almost always there's a lot of publicity with these cases, jury selection can take a much longer time than in a non-capital aggravated case. And as I mentioned, there's 2 phases of the trial. Often the penalty phase can last weeks, and there's many witnesses being called by both sides. And, of course, in a non-capital case, the jury is not doing the sentencing. The judge is doing it usually in a hearing that takes, at most, maybe a few hours. Mark's going to talk about what happens after the trial.
Thank you. Before I do that, however, I kind of want to talk a little bit about kind of wrapping this up in the sense of I'm often asked what's the difference between capital and non-capital cases, and in my humble opinion, I think there's 3 things that make capital cases different than non-capital cases. One is the requirements of collecting mitigation. That's the information about the individual, which Bob talked about, a mitigation specialist. And if you participated or watched last week, Mark Larson from the prosecutor's office talked about how that investigation collection can take a long time just to get to the prosecutor to have the prosecutor decide whether the death penalty is going to be sought or not. But even if the prosecutor does seek it, it goes even further because then it goes presumably or potentially to the penalty phase. So that's number one. Number two is jury selection, and as Bob just mentioned in one of the slides, the jury selection is much more complex in a capital case, and it's much longer in a capital case. And we talked a little bit about that last week because in a death penalty case, there's this individual voir dire where you're asking jurors about their opinions about the death penalty, which takes a tremendous long period of time. The third one is the appeals. I think the appeals are far more advanced and far more prolonged in a capital case than a non-capital case, which I'm going to talk about in 1 minute. One of the things, though, that I hope is understood here is often I get asked, well, these cases cost so much because it's the defense that's requiring it to cost so much. And what I think is so important about this study is that it showed that the cost is increased on all levels. Often folks think it's only the defense because, quite frankly, the defense's cost is transparent. And what I mean by that is in order to get expert funding, whether a mitigation specialist or an investigator, the lawyers, the defense attorneys, actually have to submit a request to the court and explain the reasons why they want these experts. And within those, and so therefore it's part of the court file, which at time the public will have access to. So what often happens is, in my opinion, is an skewed opinion about that these costs are directly associated with the defense cost. And don't get me wrong, there is defense cost clearly, but there is cost across the board. And I think what this study has done is shown that, and hopefully kind of explained in a way that these cases are expensive because they're capital cases. And because they're capital cases, they're expensive at all levels. So the third one I wanted to talk about is the capital appeals. And why capital appeals, I want to focus this only on the Washington State appeals, because that's kind of what we're talking. That is what we're talking about, is the costs associated with Washington State. When a case gets to federal court, the federal courts absorb this cost, and since the federal government prints the money, they apparently can afford it. But Washington State is a little bit different. Much like what Bob just mentioned about the special rules that triggered when it's a death case or a death notice has been filed or potentially being filed, that requires 2 lawyers and one of them at least being qualified. The same is true for appeals. If there is a death notice and a sentence is imposed, there must be, pursuant to the rules, 2 lawyers, and one of whom must be experienced in capital appeals. As Bob mentioned, at the trial level, the motion practice is more complex. The facts are more complex. As we just indicated, that the jury process is longer, and so comes with that is the record, meaning the trial court record, the information that was provided at the court, whether it's by document or testimony or transcripts during voir dire, is much larger in a capital case than a non-capital case. I mean, just give you an example, like I mentioned last week, a typical non-death penalty aggravated murder case jury selection may be 5 days. So that's 5 days of transcripts. Whereas a capital case may be 15, 20 days. So that's 2 to 3 times larger in just the transcripts of voir dire. And as Bob mentioned, there's 2 trials. You have the guilt merit phase or the guilt innocent phase, and then you have the potential penalty phase. Well, you would have the penalty phase if it's a capital appeal. And so you have 2 sets of transcripts for 2 different trials. So that adds to the length of the record, or the extent of the record. The briefing, and this is by court rule, the lengths of the briefs are far, because of the record in capital cases, the lengths of the briefs are larger. As I noted up here, non-capital, roughly 50 pages for the opening brief. For those who may not know, the way this works is the defense or the petitioner would put the opening brief, the government puts a response, and then the petitioner/defendant can do a reply brief. And so in a non-capital case, it's 50 pages for the opening brief and 25 for the reply. For capital, it's 250 pages. Often that is extended, and with permission from the court, that can be, you can file what they call an overlength brief, and often that's what happens because these cases, because death is different and the record is larger and there are more issues, that the court generally will allow for a brief to go beyond the 250 pages. And then the reply is 75 pages. And in the argument, so that means oral argument in front of the Washington Supreme Court. In a non-capital, you would get typically 20 minutes per side. In a capital case, because the court deems these so important, they give you there's 120 minutes per side. So there's an additional cost here for the Supreme Court, quite frankly, of having to review the record, review the briefing, and then take a large chunk of their day, if not the entire day, to hear oral argument they would not have presumably done in a non-capital case. Personal restraint petitions that Bob mentioned are kind of Washington's version of habeas corpus or state habeas. And what that means is direct appeal is limited to what happened at the trial. PRPs or personal restraint petitions is information or issues that may go outside the record, outside the trial. Let me give you some quick examples of that. If it's claimed that the defense attorney was ineffective, so ineffective assistance of counsel, well, that would not necessarily be on the record because if the lawyers failed to do something, it wouldn't be part of the trial. For example, if I failed to go interview my client's mother who could testify that he was with her during the time of the homicide or whatever it might be, that is not part of the trial record, so therefore it wouldn't be appeal on the direct appeal or part of the direct appeal. But it can be part of the post-conviction or the PRP, in which case the claim is ineffective assistance of counsel, and so you would have to go investigate, bring mother in, or a declaration from mother saying this is what I would have testified had they came and interviewed me. So the PRP is much larger in scope than a direct appeal. Another example of an issue in a PRP would be prosecutorial misconduct that may not have been obvious at the time of the trial, therefore not part of the direct appeal, but comes up later. And I think Bob mentioned the Stenson case that came up, and I believe those facts, I'm assuming, came up during the post-conviction, the PRP, where it was learned later that there was some inappropriate behavior by the prosecution that would not have been on the trial, at the trial, therefore not in the direct appeal, but came up in post-conviction. So this post-conviction PRP is mandatory in capital cases. It's required. It's not required in a non-capital case. And because it's required in a capital case, attorneys must be appointed. And again, 2 attorneys, one of whom must be qualified. That requirement is not there. That additional cost, that additional time, that additional resource is not there in a non-capital case. As the slide mentions, the PRP incorporates the entire case. So what I mean by that is it incorporates the trial record, potentially beyond the trial record, and the direct appeal. So if the direct appeal lawyers fail to raise a claim, then the PRP counsel may argue and raise claims of ineffective assistance of direct appeal. The lengths of these appeals, one could imagine, as I mentioned, in a non-capital case, you don't have a right to a PRP or personal restraint petition counsel. In a capital case, you do. And the lengths here are for individuals that are currently on death row are 11 years. That's currently. And those cases are at a variety of levels of appeal. Some are on direct appeal in state court, some are in post-conviction in state court, and others are in federal court. Of the cases that have been reversed, the average time period was roughly 7 years. The length of those individuals, and we mentioned last week, 5 individuals who have been executed, the average was 7 years. And to me, that's a little misleading because as we noted last week, 3 of these individuals waived their appeals. And so they were actually, those 3 situations were roughly about 3 years, I think 3 years roughly, for their execution. So this 7 years is a little misleading. In non-capital aggravated murder cases, on average, it takes about 2 years. And that's for the direct appeal. And then that is and we'll see in the next slide, if you jump to, the results of these appeals. As I mentioned last week, there's been 33 death sentences, and you can see the slide. 18 of these cases have been reversed, which is 75% of the cases have been reversed. And compare that to the reversal rates of the non-death penalty cases. Roughly, there's been 298. That's the best we can gather from. 201 appeals have been located. Some of them weren't appealed. For example, if a person entered a plea of guilty, there was probably nothing to appeal. And so these are cases that we were able to determine that actually had appellate hearings or appeals. 186 were affirmed. 15 were reversed, which is 7.5% of these cases were reversed, leaving roughly 93% of them to be affirmed. And I'm going to do one little editorial here. We talk about closures of cases or closures of the proceedings. If you want to look at closure, probably the easiest thing to do, and I'm not talking about closure for the victims because I am not here, and I do not want to speak on behalf of victims about in any way to suggest I know what the closure means for any particular individual. I'm just talking about closures of cases, closures of finality of the decision. If you look at the appeals, we said 75% in capital cases get reversed after 7-8 years, meaning they get sent back down to start the whole process over again. Whereas 93% of non-capital aggravated murder cases are affirmed, meaning those cases are no longer a part of the process. They are done. They are final. And so one of the things that we looked at was, as in the study was, not only the costs associated with capital cases or death penalty cases and non-death penalty cases, but what were the results? And this, at least in my opinion, really demonstrates, or at least puts into question, the costs associated with capital punishment and the results that that's actually being reached in these cases.
Okay, one of the things we highlighted in our study is what we didn't study, but we really wanted to call attention to the things we didn't study, and we have a long footnote about all the other kinds of costs, which include personal costs and social costs to everyone who's involved, whether it's the family of the victim, the family of the accused, the corrections people in prison, and so forth. And one of the big issues that Lila Silverstein is going to talk about next week is the role of race. And we wanted to mention this report that has just been, well, it's now 3 years old, from the University of Washington, about the role of race. And I want to just mention quickly some of the points. There's a typo in here. The actual disproportionality is more like 4 times if the defendant is black. Lila will talk about that next week. And there's a real disproportionality in how the cases are processed. The other thing that is in the race report, and that Mark also has done a lot of work on, is the difference from one county to the next. So in Thurston County, you had 67% of the cases in which the prosecutor sought the death penalty, and in Okanagan County, it was 0. So and then there was also kind of a relationship to extensive publicity seeming to drive the request for death. So we, of course, the 3 of us, and Matt Hickman, who's our colleague who also worked on it, raised the question about, is it really worth the extra expense? From our perspective, costs are not the only consideration, but if you're only looking at costs, it makes no sense, particularly as Mark points out, with the high reversal rate. And then you have the geographical differences among the counties. Our report has been cited as a reason to abolish the death penalty both here in Washington and around the country in a number of states. It's continued to be cited here in Washington in editorials. And we would love to take questions from whoever.
I have a question about the finding about the publicity correlating with seeking the death penalty. Did anyone take into account the fact that the most atrocious cases get the most press coverage?
I'm sure that was, and I think it's probably better to leave the details of the answer till next week's discussion. But do you want to take a quick?
Sure, just so I understand the question, can you repeat the question?
So there was a slide, and it talked about the cases with the most publicity are getting the highest incidences of the prosecutor seeking the death penalty. And or maybe we could go back 2 slides, and I can just see it and see what the wording is. Okay, prosecutors are nearly 3 times more likely to seek the death penalty in cases that received extensive publicity rather than in cases that did not.
Okay. Yeah. And I think that's true in smaller counties. I mean, I think what's probably coming to mind is maybe the Gary Ridgeway and those kind of cases, which is a different issue about proportionality that we'll talk about a little bit next week. But in the counties, in smaller counties, where there is a high intensity of publicity, which is understandable on an aggravated murder case, there's a lot of pressure for elected officials to seek the death penalty. Countering that, however, is the cost associated with these cases, and as I mentioned earlier, a lot of these counties can't afford it. So there is this kind of tension about publicity of an aggravated murder case or a homicide case, and perhaps wanting to seek the death penalty, but with the practical and reality of what happens financially for those counties. I think that the publicity has a factor. I mean, I think I think it'd be naive to suggest that it doesn't. I'm not so sure how we can correlate it necessarily with the cost associated with in any given county. I could say that maybe I'll put some slides up next week, that there's some prosecutors who have indicated the costs associated with capital punishment, they're just not seeking it anymore because of that cost. I'm not sure that quite frankly answers your question about publicity, but I think there is a correlation about publicity and how the elected officials try to kind of navigate the way that they want to proceed with these cases.
First of all, thank you all for your work. I just had a simple factual question because I think I missed it on one of your key slides. You said these cases cost $800,000 to $1 million per case. Was that over and above the amount it costs a non-death penalty case costs, or was that the total cost for a death penalty case?
Excuse me. The total cost for contemporary cases, like in the last decade, is over $4 million per case. The examples of the last 3 King County cases were over $5 million on a piece, and that was at the time that we had conducted the study, and the cases had not, resolved yet. So, on average, I think they're all expensive. These are expensive cases, and so we're talking millions of dollars each, and that's including, cost of incarceration. So it's a lot of money, but that's the difference in the two. Yeah.
A quick comment about cost, and I think we have seen, and it to some extent makes sense, the cost is going to continue to grow. And what we're seeing now is going to continue. In fact, I think the 3 cases in King County demonstrate that these cases are they are going to spike up, and they're going to continue to spike up. There's nothing that I see in the future that's going to bring these down, and in large part because the law changes and requirements under the Constitution that Bob mentioned, that's required of the defense counsel or prosecution or the courts, frankly, is going to continue to change, and those procedures are continue to be implemented, and so the cost is going to continue to spike. There's nothing that I see or a fix that's going to bring these costs down.
I actually ran that analysis too, just to check, because we didn't include that in our main report, but we did take a look at the trends, or I did recently as part of a question of, I conducted a study in Oregon as well, and that's one of the main findings that we found in Oregon, and I just wanted to see if it was similar, and they do map. And so we see a trend downward and significantly downward in the seeking of the death penalty, while at the same time the costs are going upward. So that's a trend not only here but everywhere.
Concerning how that money could be better spent in terms of therapy for later use, or just the cost of incarceration in general over the period of their lifetime?
I don't know that there's any, I'm sure there's an academic study somewhere. We're not familiar with one, but certainly there's lots of efforts to talk about reallocating criminal justice funds. There's the Pew Fund, Charitable Trust has been doing this work all around the country, justice reinvestment projects. And so there's all kinds of work being done on diverting cases, finding mental health treatment and alternatives, helping people re-enter society after prison. So there's a lot of work that's being done on those reinvestment projects.
I do know in some jurisdictions there's some talk about reallocating some of these funds to give to law enforcement for cold cases that have not been resolved yet and are still under investigation, which often gets kind of short, funding, and so some of this is reallocating some of these funds, or potentially reallocating some of these funds for to investigate cold cases. And
the public defense in Washington, generally speaking, is relatively well funded, although there have been plenty of problems with defense funding. And a couple years ago, the King County was looking at cutting the budget by an amount that was actually around the same amount as they were spending on the death penalty. And when you look at other states where the funding is significantly not sufficient. And even in some Washington counties where defenders don't have social workers on staff, they don't have enough support staff, they don't have enough training. If you just took one death penalty case off the table, you could address an awful lot of those issues, as well as provide funding for fixing the potholes and all the other things we need.
I'm just wondering whether you see the legislature acting on this in the near future. It was my understanding that once the governor imposed his moratorium, that there might be some legislative action afterwards. Do you know what's happening there?
Pete was down there this session.
Yeah, it didn't move out of committee this year, so unfortunately there hasn't been much movement, and until there is, the cost trends aren't going to be impacted at all. We can have a moratorium, just like Oregon has a moratorium, and costs will continue to incur as we're looking at, shortcomings in other areas, not just in the criminal justice system. But, yeah.
Certainly it would be good for people who think the death penalty should end to contact their legislators over and over and over again between now and January when it'll come back up again.
I hope it's kind of this kind of dialogue that does prompt the legislators to do something. I know last week there was some talk about voting or an initiative, and I gave my comment about my opinion about that. And the way I kind of look at it, and now that we're talked about reversals, and perhaps this is a bad analogy, but if we went to CTAC, and maybe I used this last week, and if I did, I apologize. If we go to CTAC and 7 out of every 10 takeoffs land or result in an accident, we wouldn't put that to a vote. We wouldn't vote on whether that's a good system or a process. It would be quite clear that we would get rid of it. And so that's what we have here, in my opinion, is that the legislature or the Supreme Court needs to do something about it. And because putting it to a vote, whether we want it or don't want it, doesn't really, it is not at the core of the issue.
And, we've been relatively fortunate in Washington with a judicial process that has resulted in correcting mistakes. Obviously, if you execute somebody and find out you made a mistake in the case, there's nothing you can do about that. And around the country, there are lots of examples of people who've been wrongfully convicted, who have been taken off death row and sent back home to live, who were not guilty of what they were convicted of. We have avoided that happening in a death penalty case in Washington, but it could happen here as it's happened elsewhere. And so that's another reason, from a societal perspective and a justice perspective, you don't want to be executing the wrong person.
I have a question from online. If a defendant pleads guilty, wants to waive all appeals, and simply wants to be put to death, could a state abolish the DP with a caveat, or is it a binary proposition?
The law lawyer? You want to give that a try, Bob?
I suppose the state could. I don't think. I'd want to research that a little bit. I'm not comfortable with the idea that there's only a death penalty for somebody who volunteers for it. I think there's probably a lot of legal issues with that, but I also think there's a practical problem with it, which is that it's not uncommon for someone charged with the death penalty to want to give up. And it's also very common for those people who initially give up, what are sometimes called volunteers, to change their mind within a relatively short period of time. And so if you allow a process to dispense with appeals and due process for people that think they want to be executed, I think it would be really unfair and unwise. So I think there's a lot of problems with it, and I think there's legal problems with having a system that only applies to guilty pleas.
Well, I have one, if no one else does. So the prior session talked about Furman v. Georgia as kind of a case that framed that caused a lot of states to reframe their death penalty statutes to meet their requirements. Do you think meeting those requirements is what's added some of the complexity to the cases, and what constitutional, and is it from the lens of constitutional rights of the defendants to ensure their constitutional rights?
Go ahead, Mark.
That's a loaded question that I will. I don't think there's any question that the statutes that were implemented and enacted in response to Furman because of those, that's the cost, because they're death penalty statutes. And so what has happened over the last 40 years is really there's kind of this tension. On one hand, you have to allow for individual sentencing. That's the mitigation. Otherwise, you have these automatic death sentences, death sentence statutes, which we know is unconstitutional. So on one hand, you have this requirement that the jurors must consider mitigation, which is a wide range of things. On the other hand, there's this, as we talked about last week, is this kind of narrowing focus of who can get the death penalty, who's eligible for the death penalty. And those collide with each other. It's almost impossible to have one hand a process that requires narrowing and focus and direction to the jurors, but on the other hand, having an open valve of mitigation. And so those are things that have collided. Along those same lines as there's been, and understandably so and rightfully so, because death is different and it's irrevocable, there's a higher level of reliability, which comes with a higher level of scrutiny and a higher level of protocols and process, many of which we talked about today, the 2 lawyers and stuff like that. So that is a byproduct of the statutes. And so the statutes and the implementations of the statutes of the last 40 years have changed, not the statutes themselves, but the application of the statutes have changed tremendously. And in fact, may have been mentioned last week, a United States Supreme Court justice finally said, he got fed up and said, I will no longer tinker with the machinery of death because there's been so much tinkering to make it constitutionally valid under Furman. And he just threw his hands up and said, I will no longer tinker with the machinery of death. And that's kind of, that is part of the cost.
It's almost always the case that someone charged with capital murder has significant mental illness and or a brain injury. The very first thing I used to ask my lawyers when I was running the defender office in Seattle, and we had a potential capital case, is what kind of brain injury has this person had and what kind of mental health treatment have they already had? And almost always you had one or both of those things. And in order to understand fully the entire life of the client that has included that mental health issue requires an enormous amount of work. And usually we were able to persuade the King County prosecutor that because of those mental health issues, they should not seek the death penalty. It was in the time I ran the office for 28 years, and we only had one case that went to the penalty phase in that entire time, and that was a client who pled guilty in the guilt phase. So most of the time, and it's, as Mark said, it could take 6 to 12 months to develop that information because very often the clients lived in another state or even another country, and you have to go get that mental health information and the school information and the family information and the parents' information. And then usually we were able to persuade the prosecutor, don't seek death because of these mental health issues. But when death is on the table, all of that has to be explored even more fully and comprehensively than it might be otherwise. And it's just an enormous expense. Very often you have to get not only psychologists and psychiatrists, but you've got to get neurologists and all kinds of medical testing done. And of course you can't just take your client to the doctor's office when they're in jail. You have to have all kinds of expensive custody arrangements to have those kinds of tests done.
Well,
7 seconds left.
That concludes the session today. I hope you attend next Monday when we discuss whether there's disproportionate applications of the death penalty. Thank you and have a good afternoon.